early origins. While the modern international system can be traced back some 400 years, certain of the basic concepts of international law can be discerned in political relationships thousands of years ago. Around 2100 BC, for instance, a solemn treaty was signed between the rulers of Lagash and Umma, the city-states situated in the area known to the historians as Mesopotamia. It was inscribed on a stone block and concerned the establishment of a defined boundary to which respected by both sides under pain of alienating a number of Sumerian gods. The next major instance known of an important binding international treaty is that concluded over 1,000 years later between Ramesses II of Egypt and the king of the Hittites for the establishment of eternal peace and brotherhood. Other points covered in that agreement signed, it would seem, at Kadesh or North Damascus included respect for each other's territorial integrity, the termination of a state of aggression, and the setting up of a form of defensive alliance. Since that date, many agreements between the rival Middle Eastern powers were concluded, usually aimed at embodying in a ritual form a state of subservience between the parties or attempting to create a political alliance to contain the influence of an overpowerful empire. The role of ancient Israel must also be noted. A universal ethical stance coupled with rules relating to warfare were handed down to other peoples and religions, and the demand for justice and a fair system of law founded upon strict morality permitted the thought and conduct of subsequent generations. For example, the prophet Isaiah declared that sworn agreements, even where made with the enemy, must be performed. Peace and social justice were the keys to man's existence, not power. After much neglect, there is now more consideration of the cultures and standards that evolved before the birth of Christ in the Far East, in the Indian and Chinese civilizations. Many of the Hindu rules displayed a growing sense of morality and generosity, and the Chinese empire devoted much to harmonious relations between its constituent parts. Regulation controlling violence and the behavior of varying factions with regard to innocent civilians were introduced, and ethical values instilled in the education of the ruling classes. In times of Chinese dominance, a regional tributary state system operated which fragmented somewhat in times of weakness, but this remained culturally alive for many centuries. However, the predominant approach of Asian civilizations was geographically and culturally restricted. There was no conception of an international community of states coexisting within a defined framework. The scope for any international law of states was extremely limited, and all that one can point to is the existence of certain ideals, such as the sanctity of treaties, which have continued to this day as important elements in society. But the notion of a universal community with its idea of world order was not in evidence. The era of classical Greece, from about the 6th century BC and onwards for a couple of hundred years, has, one must note, been of overwhelming significance for European thought. Its critical and rational turn of mind, its constant questioning and analysis of man and nature, and its love of argument and debate was spread throughout Europe and the Mediterranean world by the Roman Empire, which adopted Hellenic culture wholesale and penetrated Western consciousness with the Renaissance. However, Greek awareness was limited to their own competitive city-states and colonies. Those of different origin were barbarians, not deemed worthy of association. The values of Greece in a study of international law lies partly in the philosophical, scientific and political analysis bequeathed to mankind, and partly in the fascinating state of interrelationship built up within the Hellenistic world. Numerous treaties linked the city-states together in a network of commercial and political associations. Rights were often granted to the citizens of the states in each other's territories, and rules regarding the sanctity and protection of diplomatic envoys developed. Certain practices were essential before the declaration of war, and the horrors of war were somewhat ameliorated by their exercise. For example, the religious customs regarding the sanctuaries. But no overall moral approach similar to this emerging from Jewish and Hindu thought particularly evolved. No sense of a world community can be traced to Greek ideology in spite of the growth of Greek colonies throughout the Mediterranean area. This was left to the able administrators of the Roman Empire. The Roman had profound respect for organization and the law. The law knitted together their empire and constituted a vital source of reference for every inhabitant of the far-flung domain. The early Roman law, the jus civile, applied only to Roman citizens. It was formalistic and hard and reflected the status of a small and sophisticated society rooted in the soil. It was totally unable to provide a relevant background for an expanding, developing nation. This need was served by the creation and progressive argumentation of the jus gentium. This provided simplified rules to govern the relations between foreigners and between foreigners and citizens. The instrument through which this particular system evolved was the official known as the praetor peregrinus, whose function it was to oversee all legal relationships, including bureaucratic and commercial matters within the empire. The progressive rules of the jus gentium gradually overrode the narrow jus civile until the latter system ceased to exist. Thus, the jus gentium became the common law of the Roman Empire and was deemed to be of universal application. It is this all-embracing factor which so strongly distinguishes the Roman from the Greek experience. Although, of course, there was no question of the acceptance of other nations on a basis of equality, and the jus gentium remained a national law for the Roman Empire. One of the most influential of Greek concepts taken up by the Romans was the idea of natural law. This was formulated by the Stoic philosophers of the 3rd century BC, and their theory was that it constituted a body of rules of universal relevance. Such rules were rational and logical, and because the ideas and precepts of the law of nature were rooted in human intelligence, it followed that rules could not be restricted to any nation or any group but were of worldwide relevance. This element of universality is basic to modern doctrines of international law, and the Stoic elevation of human powers of logical deduction to the supreme pinnacle of discovering the law foreshadows the rational philosophies of the West. In addition to being a fundamental concept in legal theory, natural law is vital to an understanding of international law, as well as being an indispensable precursor to contemporary concern with human rights. Certain Roman philosophers incorporated those Greek ideas of natural law into their own legal theories, often as a kind of ultimate justification of the jus gentium, which was deemed to enshrine rational principles common to all civilized nations. However, the law of nature was held to have an existence over and above that of the jus gentium. This led to much confusion over the exact relationship between the two ideas, and different Roman lawyers came to different conclusions as to their identity and characteristics. The important factors, though, that need to be noted are the theories of the universality of law and the rational origins of legal rules that were founded, theoretically at least, not on superior force but on superior reason. The classical rules of Roman law were collected in the Corpus Juris Civilis, a compilation of legal material by a series of Byzantine philosophers completed in AD 534. Such a collection was to be invaluable when the darkness of the early Middle Ages following the Roman collapse began gradually to evaporate. For here was a body of developed laws ready-made and awaiting transference to an awakening Europe. At this stage, reference must be made to the growth of Islam, its approach to international relations, and law was predicted upon a state of hostility towards the non-Muslim world, and the concept of unity, Dar al-Islam, as between Muslim countries. Generally speaking, humane rules of warfare were developed, and the peoples of the book, Jews and Christians, were treated better than non-believers, although in an inferior position to Muslims. Once the period of conquest was over and power was consolidated, norms governing conduct with non-Muslim states began to develop. The law dealing with diplomats was founded upon notions of hospitality and safety, aman, while the rules governing international agreements grew out of the concept of respecting promises made.